you need to understand what intellectual property assets that you have. And to do that, you need to understand the chain of title, which Jay mentioned in the previous speech, that you need to understand where that chain of title is, what you own and how you own it, and when you lose it, if you're ever going to lose it. So why don't we start with giving an introduction to everybody, and then they can just, instead of going into your topic, just kind of identify what your topic is going to be. Then we're going to kind of rotate and give everybody a chance to kind of identify it. Why don't we start, ladies first?
As I'm the only one. I'm Stephanie
We also have Jay.
I'm Stephanie Fergang-Adwar. I'm a partner in Fergang & Adwar in New York City. We are an intellectual property and entertainment law firm. We do litigation and transactional work. I advise clients both from the entertainment side and the IP side. And my topic is going to be on co-branding, which is behind me, which is the value of the trademark as used with others' trademarks. And I will go into that in a little depth as we go along.
Okay, you know me. I'm going to talk a little bit later on about value as it relates to value set through government systems like the compulsory licenses and value in the free market and how that plays out in being able to sell your company, and for better or for worse.
Jump to the far end.
I'm going to be handling, I'm John Toranian. I'm a founding partner at One LLP, an entertainment and intellectual property firm based in Southern California. Also the Paul Wildman Chair and Professor of Law at Southwestern Law School. And I'm going to be covering several issues regarding copyright law and new technologies, including talking about the DMCA safe harbor and things that new technology creators need to be aware of, as well as intermediate liability and some issues involving the authorship doctrine in copyright law.
Hi, Greg Zigarelli from Pittsburgh, practicing 28 years, corporate clients, business clients of all different types and sizes. I think I'm going to support Stephanie on the trademark side, so we've got a couple of trademark discussions as well as a few copyright discussions.
My name is Scott Canale. I'm an attorney practicing in an entertainment law firm, Canale Kumar in Atlanta, Georgia. In addition to that, I also work as an adjunct professor at Georgia State University, teaching entrepreneurship, legal aspects of music, and artist representation, and chair a big entertainment law continuing legal education, which we have every year down south of the border. This year we're going to be in Playa del Carmen, Mexico. It's the North American Law Summit. Good time. Actually, yeah, these two have always been doing that some more there. So, as I was kind of talking about this, you just kind of heard where everybody's going to go, because there's a lot of concerns when you've got a company, because what I was saying is the assets are the value of the company. And just, so many people argue, I want to do record deals where the artist gets to own the masters. Like, well, that's the value of your company. And so if you're going to do a record deal, you need maybe take that into consideration, although it's very generous, but it certainly dilutes the value of your company. But when I'm setting up these new technology companies, one of the first things I want to look at is what IP do we currently have at the time that we're setting it up. So generally, somebody's got an idea, but do they have anything more than an idea? Do they have possibly a trademark? And we have the trademarking on that. We usually want to make sure that gets assigned in some kind of intellectual property assignment, just to get the name into the company, so it's owned by a company, because someday that whole company may fall apart, or the guy who came up with the name of the company gets kicked out and says, well, that's my trademark. I own that trademark. I had it when I came in. And so you want to get something like that cleared up, but also in terms of copyrights, especially these new technology companies, oftentimes they have a software, and the software is a copyright. However, it's a copyright in literary section. So when you're filing, you're doing it under literary section of the Copyright Act, and you're using that form. So put a pin in that, because we're going to come right to that, and you're going to understand where I'm coming from on this. So when we get the software kind of set up, we want to know who owns the copyrights at this point in time. So when we're doing this, you got to start looking at it. Copyrights are, did you create the copyright? Did an employee create the copyright? Did you commission the creation of a copyright? Or were you assigned the copyright? All those are important to know when you're trying to decide what the company owns. So I'm basically coming up with these kind of answers on it. You start looking at different scenarios onto this, but The first best scenario is that you created the copyright in the company as an employee. Because an assignable copyright is all of a sudden subject to copyright termination at some point in time in the future. So if you got this going into the company, you may lose the value of the company 35 years down the road when copyrights are subject to termination under 203 and 304 of the Copyright Act. So you want to make sure it gets done by an employee, but that's why you got to also have problems in determining whether this person is going to be an employee, which all of a sudden now you've got employee rules that you got to stamp on this. And if you got the employee rules, then you got to follow the federal government and state government rules on what the employment laws are in terms of that employee. But when we start looking at the whole setup on this, we're looking at a work for hire. The work for hire concepts of copyright law are essential for you to start your breakdown of what you guys own. So the first part is, did an employee create it? If an employee created it in the course of the job to which they were hired, then that product is a automatic work for hire and it is owned by the company. And the benefit of having it as a work for hire owned by the company, then it's got a 95-year shelf life. So the next part about that is, you start making the determination, was it in the course of their employment? And when you're looking at that, you can have a secretary work at the front of the company. They come up with this great idea, they're working on the side, and it has nothing to do with what their job is in the company. Then all of a sudden, that's not in the ordinary course of their business. It's not considered work that would be created by an employee. So you need to know exactly you need to know exactly which way the product is created, and once the product is created, get it under that employee status. If it is not an employee, if you're going out to a third party, and when we start looking at third-party commissions under a work for hire doctrine, as an independent contractor, you've got certain rules under the work for hire standards. You want to specifically commission it, but it's got to be within these 9 particular areas. And those 9 areas are, let's kind of read down on them and explain them to you. A contribution to a collective work, as part of a motion picture or other audio-visual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas. So as you sit here, as probably a lot of you do, a lot of music-related law, since this is a music conference, I'm assuming that's the case, but you also notice that what's not listed on here are sound recordings or composition copyrights. So those way aren't on there, but you may be able to make an argument in terms of an asset for the company being an album. You can argue it under a compilation. However, the courts seem like they're pretty split on that right now, and I'm not seeing a lot of confidence in passing the judgment and telling my client that's why you're going to have a work for hire on this. But as I identified the issue with software, which could be your entire company format, you'll see that software is not on here either, but software is under the literary form for the filing. However, if you are in a video game business or if you're in some kind of gaming business on the internet using music, you can also argue that, and I think successfully argue, that the work for hire is now under an audio-visual work, which would fit under the copyright standards. I generally, especially in software issues, I generally want to work where my client is filing for the work for hire, but if it's in some kind of audio-visual. But I generally also want to identify whatever they're hiring an independent party to do, I generally want to say, have a backup plan. And your backup plan should be, you are a joint author at best. So you're a joint author in whatever it is, you came with the idea, you directed this person how to do it, you worked with them, you walked them through the process, this is what we want you to do, as that person was doing. It's kind of like maybe you had somebody who could play a song sitting there, who could play an instrument, you're saying, I want it to sound like this, I want it to sound like this, I want it to sound like this. You're creating the copyright, you're really kind of creating the elements of the song. But the reason I do that, and I'll also follow with that, any portion that you shall own as a co-author of the copyright, then you shall be designating this as a work for hire. If it is not designated as a work for hire, you shall therefore assign. But why do I want it to be a co-author? Why is this so important? When I get it to the joint authorship, that I also get it structured where my client has the right to license it and the right to continue using it, no matter what happens, no matter what kind of litigation or anything's going on out there, or whether termination structure at some point in time or assignment time lapses, or it was not a proper assignment, or whether it's not considered work for hire, my client can still continue using this, and we have a very good argument we can use in the courts at that point in time. But I think that's kind of a good start on kind of understanding what we're doing with that. I could go into this topic probably for the rest of the day. I'm trying to speed through it so we can get kind of some of these other panels up to time on where we are, so we started so late. But let's kind of move on to co.
Okay, so co-branding has been used for the last few decades now to join together the trademarks of two different parties to promote the value of both of them. Most obviously, probably in music, off the top of my head, I can think of Les Paul guitars and maybe Aerosmith's and Disney, their rock and roller coaster, Disney World. But there are lots and lots of uses in co-branding, and there are opportunities for your clients to join with other parties that may not be so obvious, but may create opportunities to expand their market share. So some obvious ways, and these vary across many different kinds of goods and services. We have, let's see, Dunkin' Donuts, Baskin Robbins. You know, have you been in these stores and you notice that they're both together? That's a co-brand. That's a co-brand. Okay. Barnes and Nobles and Starbucks. See them together. So there are two types of co-branding opportunities. The first is equivalent brands. So you have two brands of similar stature and they are housed in the same location or they're merged into existing goods. So for the, you have here Starbucks and Pizza Hut and Target, right? So you have Starbucks with Target and Pizza Hut with Target. They're housed under the same location. That's the equivalent brand situation. And then you have, oh, and I have another one, actually, Disney and Seiko. So you have the Seiko watches, or Seiko clocks, and Disney characters. The second type of co-branding is the creation of new branded product, which means each of the parties are putting in their technology, their invention, their work, and they're merging it into a new product. So examples of that are things like this. We have the Pottery Barn and Benjamin Moore joined together to create a line of paints specifically directed towards the Pottery Barn color schemes. So they developed a line of colors and put out this color wheel called Experience Colors. Another one is Bonnie Bell and Dr. Pepper, bringing you the best tasting and best colored lip gloss ever. But what they did was they merged the flavor with Bonnie Bell's product. It's really, really old, so it gives you an idea of how old I am. Next is the benefits to the brand. So why do you do this? Well, in the first place, it introduces brand owners to new audiences. So if you're Nike and you have you're selling your sneakers to the general public, but you want to get in front of, let's say, maybe a portion of the population that doesn't wear running shoes, you might want to add your brand. Hold on, I gotta figure out how this works to the next one. Okay. Well, you might want to add your brand to to another product like Cole Haan shoes. So Nike Air Technology worked together with Cole Haan, made a brand of shoe that was now saleable to fashionable people who wouldn't necessarily wear running shoes out as regular shoes, but wanted the comfort of running shoes. It also allows you, because you're opening out who you're selling to, you're increasing your market share. So now your brand is becoming known not just to the original parties that you used to sell to, but also to an entirely new group of people who will become familiar with your brand. And lastly, it allows you to share the burden of maybe some failure, but certainly the success of that with another party. So you're sharing the expenses of co-advertising, you're sharing the expenses of how you put this whole thing together, your advertising companies and so on, and then you're sharing the benefit of it together. The risks, however, are pretty obvious. Tarnishment, dilution, and damage to the actions of co-branded partners. Now, where this happens is when you're a brand and you merge with another brand, and the other brand does something that casts a bad light on you. So if you have a great product and the other party does, and let's say you're a food product with something from non-food product, and your food product gets somehow compromised and causes people to get ill. The non-food product part of that co-branding opportunity is going to be very upset with the fact that people are getting sick of a product that now has their name on it. So that is a huge risk, is that your brand may be compromised by the actions of another company. So you have to, when you are representing parties who are going into co-branding deals, you have to be very, very careful that they have in place the same quality control, the same importance, all of the same things that you do, and the same value on the mark. You should, I have clients who have done a number of co-branding deals, and when we start doing these things, we start analyzing their market share, who they sell to, and what the possible ramifications could be if something goes wrong, and what could go wrong. So it's your job to figure out, obviously, like we do in so many other situations, what's the worst that could happen? How bad could this get? And if your answer is, a lot of times what happens in this is you go, it couldn't be that bad. You know, we're not with a food company, they're not gonna poison anybody, you know, what's the worst that happens? The shoelace breaks or something, you know. Those kind of things, you go, all right, that seems to be a good way to weigh this. Sometimes the benefits are not outweighed by the potential risk, and those are the times where you think about maybe this isn't the best type of co-branding. Lots of companies and lots of my clients will come to me and say, well, I want to do have an arrangement with another company where we can sell our products to them, so I think our product would be great with that product. That's all wonderful, but they're going to take into, that other product or company is going to take into consideration the value of your client's mark and how the risks that could happen to theirs, and especially in a situation where you're the attorney for a smaller brand wanting to partner with a larger brand, you have less negotiating power, you have less power over the whole entire deal, but you also, they're going to take into strong consideration what risks you can raise with their product. So you want to be very careful about how that risk benefit works, and so that you can argue that properly to the people that you're trying to sell it to. Let's see. Okay. So there are these practical considerations when you're doing this. You want to make sure that the arrangement is beneficial to your client's brand. So you want to make sure that there's nothing within the company's history or the brand's history that may reflect poorly on your brand. You want to make sure that you're getting to the right market. There are a lot of times when your clients come to you with a particular branded product, their market, who they are selling to is very targeted. And while they may want to expand that brand, they also want to make sure that they're reaching the right people who are going to buy their product. Because it's not going to be worthwhile to do that kind of a deal if the people who are buying the co-branded product are buying it solely because of the other brand, and it really has nothing to do with you and it doesn't give you any added value. So you want to make sure that you're branding your product with something that will be a good value deal for both parties. And you want to make sure that you can maintain control, that your client's control over their trademark is maintained. You don't want to enter into a deal and find out later that there's wishy-washy language within the deal that's going to allow them to maybe own your trademark, or maybe have some sort of control over how that product is distributed in a way that where you can't control it. And that's a very, very crucial thing for you to watch. You always want to make sure, when you're the attorney for a trademark owner, you want to make sure that your trademark owner is very well insulated and either can get out if they need to get out, and make sure that there are quality protections within the agreement that allow them to get out if they need to. So here are the kinds. So this is a very quick little. I know I'm speaking very quickly. I'm trying to get through this so that everybody can have their turn. But we have always been a first to use country. Most foreign countries are first to file. So you want to make sure before you go into some worldwide distribution of product that your mark is protected in those other countries as well and can be protected in those other countries as well. You don't want to have a situation where you go out into the world and say, okay, here's my product, and you find out that somebody else in those countries has a registration for that and you can't use it there. Term and termination. Well, no, obviously how long this is going to go. Sometimes these co-branding arrangements happen for short periods of time. They're limited, they're meant to be, a lot of the fast food companies have these small limited time offers of a particular product or that are co-branded. If it's a limited time, great. So you set that forth, you make sure that that's clear, and you want to know how to get out of it. There are the 5 rules of contract, right? How do I get into this contract? What do I have to do? What do I have to do to get into this contract? Now that I'm in this contract, what do I do? How do I get out of this contract? And how much is it going to cost me to get out of this contract? So those are the things you have to consider in terminating. How do you get out? What happens? What happens in the situation where there is a problem? How do you terminate? How do you say, I got to get out of here, there's a breach, or there's the other company's product isn't what I thought it was going to be and isn't reflecting well on my product? Are there provisions within the contract that give me the ability to pull my client out so that in the event that those representations are not adequate and what they've told us about their product and what they can do don't live up to the hype? And then you have reciprocal use, right? So when you're co-branding, you're using someone else's mark with your mark, they're using your mark with theirs. So you want the parameters of what that looks like. You want to know where they can advertise it, how they can advertise it, how they can sell it, where they can sell it, what they can't do. If your particular product is within a particular class of goods and services, and the other parties is in totally different goods and services, you want an agreement between the parties so that that party, that co-branded party, can come into your territory after the termination is trying to trade in on what they've just established. So you want to make sure that there's delineation of right from the beginning, and make sure that your client is protected in the case of the worst case scenario where somebody doesn't live up to the expectations of both parties. You want to be able to make sure your client can monitor your use. You want reports, you want promotion and advertising. You want to make sure that all of those things are checked by the people in your client's company. You want to make sure that they're able to approve all forms of advertising and promotion and have sign off on that so that nothing's going out before they know. That could, because anything that they decide and put out could have the effect of putting out something that isn't what the client's company wants to happen. So if you have a particular way of selling your product or your services, and it runs within a certain plan, and another company comes along and they have a different way of operating, and they want to guerrilla market your product all over, but you have a much higher level of advertising, that could be a problem. So you want to make sure that you're on the same page with the other company, make sure that you have all of those parameters set out within that agreement. Don't wait until, okay, we got this deal and we're going ahead, and then all of a sudden you find out, well, they want to advertise this way, and you had no expectation of them advertising that way, and there's nothing within the contract that dictates it. So that should be done as well. And last are the financial parameters. Who's bearing what costs? Are there royalties to be earned from anything, and how are those royalties then divided between parties or not? Those are the most crucial things that you have to have in your contract. If you pay attention to these things while you're doing these deals, inevitably when you come out of those deals, I mean, sometimes they're really long-term contracts, like Dunkin' Donuts and Baskin Robbins, right? They're meant to be together for probably forever. So they're looking for a lifelong, joining of those two parties. That's not always the case. So you want to make sure that your clients have the right expectations of what's going on, and you want to make sure that everything that you are doing within these contracts are what your client is expecting, so that the value of their mark grows instead of diminishes. That growth of that of that mark will allow you to be able to assist your client in transferring rights if and when your client wants to sell that mark or sell that company. These are the things that can grow the value exponentially. So they're fabulous opportunities. And I work with advertising people and branding companies all the time in all kinds of different areas and different fields and genres, but though it's inevitably the same question is, how do we grow, how do we benefit each other, and how do we make sure that our mark is protected while their mark is protected as well. So keep those things in mind. If you want to know more about this and you want to talk to me about it, I'm happy to talk to you about it, and I will let you move on to that.
You did okay with that.
Great, take off.
Okay. First of all, I understand everyone has their materials that have been distributed. So there are, for this session as well as the earlier crowdfunding session, I think I consolidated some good materials for you. So I encourage you to look at the written materials that you can download. Scott and Stephanie are absolutely right. The flaws associated with intellectual property mistakes will manifest on a merger or an acquisition later. So all the problems that are early on or you can get through, they will come back at the point of the sale of a company, a merger opportunity. So early is really the time to be careful with it. Trademarks are different than copyrights. Trademarks exist in federal law and state law. So it's a dual system. So you can have state trademarks and you can have federal trademarks, just to get that dichotomy out of the way. The difference between a copyright and a trademark, sometimes clients will call and they'll say they want a copyright when they mean trademark or vice versa. If you sit down and paint Mickey Mouse, if that's an original work, you own the copyright. You're the author. As soon as you put Mickey Mouse on the masthead of an amusement park, so you create a commercial impression, it becomes or could become a trademark. So you could have the same subject of intellectual property protected by copyright and protected by trademark. You can file for the copyright, of course, many of you know. You could also rely on a trademark that is unregistered with the government, and you can also register the trademark with the government. As Stephanie mentioned, you will acquire rights in a trademark on use, at least in the United States. So as soon as you use a brand in commerce, you will acquire trademark rights. If I today start selling a vacuum cleaner with the name Hoover and nobody's done it before, and I only sell it between here and Georgia, I will acquire common law rights in that market territory. The value of a federal registration of a brand is that you will acquire rights throughout the United States based on a constructive use. So by registering a brand, you not only get the rights where you've actually used the brand, which you get a common law, you will acquire rights through the entire United States. So that's the value of registering a brand. Where do you register a brand? It's at the Federal Patent and Trademark Office, and if you have not yet been on USPTO, the United States Patent and Trademark Office, uspto.gov, you definitely should become familiar with that website. That website is the governmental repository for all of the federally registered trademarks. So, as soon as a band or really any commercial client comes into your office, presumably doing something regarding which they want to make money, so there's a commercial reputation associated with it, you should be immediately thinking about a brand. So in my office at least, there are so many more brands registered than copyrights because every single business has a brand, if not multiple brands. And multiple brands could be a name, Nike. Just do it. That's a slogan. The swoosh logo. Okay, so you have for Nike the triumvirate. You've got a name, a slogan, a logo, all separately registrable with the federal government, all of which can build significant value for your client. When I go to see a band and they're playing great, and I say to somebody, who is this? That's sort of a problem. And I have many clients in business that would, if that were their service, would make them just inflamed. Every time somebody goes out and whether we're doing it as attorneys or a band, there should really be marketing collateral. So really, you always want the audience to know who is it that's providing this service, because that reputation is crucial. So one of the important things is you can't go back in time. So whenever you think about a brand, you can start to use it somewhere, and you get rights where you use it, you can register it with the federal government and get constructive use over the United States. But what you cannot do is oust someone that has used that brand or anything substantially similar before you. So now where it gets tricky is, I have clients all the time that'll say, I love this brand, and they spend a lot of time thinking about it, and maybe they invested a lot of money in it, and I'll say, you can't have it. And they'll come up with a lot, after having researched USPTO.gov and researched it. And I say, look, let's assume they're male. I'll say, look, you may be in love with her. That doesn't mean you can have her, okay? She might belong to someone else. And that's the way I describe it. Just because you like it doesn't mean you get to have it. It's a basic concept. People, for some reason, understand that it occurs everywhere in life, and it occurs the same way with a brand. One distinguishing characteristic about trademarks is you don't actually need a brand that confuses the public. It could also create an untrue affiliation. So, in other words, let's say I say to you, YMCA and YWCA. Are you confused? You say, why, of course no. I know young men and I know young women, and men aren't women, and I don't get confused by that. Say, okay, maybe that's not a trademark confusion standard infringement. Do you think the YMCA and the YWCA are affiliated? Why, yes, I do. I'm not confused, but I do think they're affiliated. Trademark infringement, okay? It's a warm and fuzzy assessment that may, and does to a lot of my clients, drive them a little crazy. They will come up with reasons why a brand that's a little bit different than somebody else, but they're doing it too. There are a million reasons why two people can have similar brands and have evolved for some reason in the marketplace. It could be somebody flew under the radar, there were concurrent rights, it's under a different statute, there's all sorts of reasons. But the bottom line for you as practitioners is, when anyone comes in your office, a brand is a significant part of the advice, a significant initial question, whether it's a band name, an album, corporate name, product, service, whatever it is. It's just something to stick on. Google it, see if the domain name's available, go on ups.gov, uspto.gov, and check it, and you can go from there. Again, the materials have a lot of the details in it. By the way, Stephanie also mentioned about controlling the brand. Under trademark law, if you let somebody use your brand, let's assume it's your brand. If you let someone use it, two things can happen. You can either acquiesce to the use, and you're going to lose rights in it, or there's also something called naked licensing, meaning somebody else has used it with your permission, and you didn't control your brand, so now you got like a McDonald's hamburger made one way here, and a McDonald's hamburger made a different way here. If that occurs, the standard of reputation isn't consistent, and you can lose a trademark right. So you have to be very careful to police and to monitor in all your licenses the standards that you use for a brand. One last thing, if you didn't catch it, Scott had mentioned termination of copyright rights. If you didn't catch that, it is actually an important point that copyrights can be terminated later by heirs. And the way you assign a copyright is very important. So if you have questions about that, you can address that in the question portion, but it is important. And it ties into the transfer, how the transfer was made during the life of the copyright.
Yeah. Just kind of follow up on a couple of your things, and kind of see that there's a lot into this, and we're not even going to cover patents. And that's a whole nother ball we don't want to jump into. But Oftentimes I get people come to my office, especially bands or somebody wants to start an indie record company and they say a name, and I'm like, well, I think there's already one out there, but I'm spelling mine differently. And I'm like, well, that doesn't matter. It comes down to whether it causes confusion in the marketplace. And as Greg went over that perfectly, actually, that was very well done. It's just whether it causes confusion in the marketplace, and you really can understand that. But I also want to identify that when you're looking for these, you come up with kind of an interesting name, that you can have an interesting name that somebody may be already using, but in a completely different class. Maybe they're using it in some kind of electronics when you want to use it in entertainment music. So look at everything to make sure that there's nothing else in your class. I'll generally say, and I find the USPTO to be a really good starting place, but there's companies out there that you can pay them $600 or $700 and they will go look at everything, try to find a name for you. I find Google is amazing, and here we are giving Google hundreds of props when we probably hate them for so many other different reasons. But Google a name, so if you want like X trademark and records, but don't just do that in quotes, because it may come up where it's that same name with entertainment, or that same name with productions, or that same name with music. But just make sure you cover all those different establishers that go along with the name, to make sure that there's not something else in the marketplace out there that's exactly the same. Just
I want to just throw one thing in that vein. The search firms who do these comprehensive trademark searches that you were talking about are search companies that search not only the USPTO and state trademark registrations, but Dun & Bradstreet business listings, yellow pages, domains, any place where anything could be used that could be confusingly similar with the mark that you're looking for. That search will do a Boolean search, so it'll break the name apart into pieces and will show you all of the possible hits that you have. And then you are expected, by the way, they don't go through it and analyze it. You are expected to analyze that search and be able to report to your client where the risk is for using that particular mark. And courts, when there are disputes in this type of vein, they want to know you did a search. They want to know that you did it comprehensively and that you did it correctly. Because if you didn't, they look at it and they go, well, you didn't really pay attention. You didn't really look. You didn't really care. So it's really important that you make sure you do those searches properly and analyze them properly to make sure that there's no overlap in the goods and services.
Yeah, I'll let you know that. Well, I was going to follow from that is that, yeah, you got to do it. And here's why it's really important, because, spending the money to have that search done, then having lawyers go through it to make the determination. The book is back, it's thick, and it's obnoxious. You can get a lot of that done, but a lot of times you might say, for as cheap as it is to file a trademark, maybe I can just drop it later if I get caught on it. Asking forgiveness later, but even though you think that there's nothing out there, you did make somewhat of a diligent effort. But I think that the cost of changing your brand midstream is a lot more than changing your name of your brand at the beginning.
Yep.
I've seen companies go out of business because they were forced to change their name midstream. You have to you lose the goodwill. And you're mentioning that Apple issue. Yeah,
I was just going to mention, if you Google Apple Computer versus Apple Records, okay, that was a real case. Apple, you see there's Apple Computer and Apple Records. Computers weren't thought at a certain point to go into music and art and all that sort of thing. But if you Google it, you'll get the Wikipedia description of it. It's interesting as to how that case proceeded, Apple Records versus Apple Computer.
Yeah, Paul.
Actually, that was a contract case.
That's true.
In 1981, when computers and music were totally separate, the Beatles company and Jobs company made an agreement. If it's computers, it's yours, and if it's music, it's yours. And then about 10 years later, the MIDI came out, and it was a violation of the contract. And there was a lawsuit, and there were tens of millions of dollars paid, and the thing was reformed. And then finally, when iTunes came out, it got even more complicated, and there was a huge lawsuit, and yet another big resolution. So it's
You're absolutely right. But it's great. It's it's interesting reading, and you get a flavor for it.
Right.
John's done.
John, jump in.
Yeah, I'm going to build on what Scott talked about in terms of what you need to look for as a new company, especially in technology field. With respect to your copyrights, I'll first take a step back, talk a little bit about some basic copyright concepts, and then go in a little deeper with a few particular areas, including looking at the DMCA Safe Harbor, which Jay talked about in legislative update section, looking at some authorship issues, and also talking about intermediate liability in copyright law. So the first basics, kind of building on what we're talking about, copyrights are very distinct from trademarks. Copyrights, the basic definition is they're any kind of original work of authorship that is fixed in a tangible medium. The standard is very, very slim, which is set by a case called Feist from a number of years ago involving rural white pages. Basically, you just need a mere modicum of creativity in order to have a copyright. Your work does have to be fixed in a tangible medium. In other words, me just giving a lecture doesn't count unless it's recorded, right? Unless it's fixed in a tangible medium. Or skywriting doesn't count, a ballet doesn't count unless, again, fixed in a tangible medium. And generally, the work has to be a work of authorship. There's been some controversy in recent months or years about what this means. I'll talk a little bit about that. But one of the most notable cases in the last couple of years is the case of a gorilla. I'm sure you're all familiar with the crested macaque. Known as Naruto, or Naruto, what is it, Naruto? Who sued a photographer over copyrights, right? The gorilla took a selfie that famously appeared in headlines around the world, and animal rights activists on the gorilla's behalf basically sued to have it determined that the animal, because the animal actually took the photograph, was the copyright owner of the photograph. The camera owner, a photojournalist, disagreed and believed the copyright belonged to him. The U.S. Copyright Office got involved in their compendium of copyright, issued a ruling, or federal reg, that basically said that animals can't own copyrights, and the issue is now in front of the Ninth Circuit. So it should be an interesting issue. So one thing to consider is, do animals own copyrights? Which, it's kind of a fascinating issue. We've talked a little bit about formalities here, and as we talked about earlier, a trademark comes into immediate existence through common law rights. You don't necessarily need a registration by mere use and designation of source or origin of a product. You can register it, and there are benefits to that. Copyright, similarly, we are told has no formalities, and that's true to some extent, and I kind of want to warn everybody about that, which is, it is true that the second you create a work of authorship and fix it in a tangible medium, it is copyrighted. If you're taking notes right now, those notes are copyrighted. If you do a doodle on a paper, a cocktail napkin, that's copyrighted. But there's a big difference between owning a copyright and going out and enforcing a copyright. And this is a huge thing for what Scott was talking about, which is when you're talking about a portfolio of intellectual property that the company owns. Yes, you may own a bunch of copyrights, but if you have not registered your copyrights, your ability to go out and enforce them is severely damaged. And this is almost the first question I ask in any piece of litigation that comes across my desk involving copyrights, which is the copyright registered? In my opinion, it's a very stupid question to have to ask because it elevates formalities over everything else, but it makes all the difference in terms of the value of a case in most cases. And here's why. Although we are told that our copyright regime doesn't have formalities, it does. And the biggest formality it has is you need to register a copyright with the Copyright Office, and this is an important point. That means with the Copyright Office, not with something like this, with the Writers Guild of America, right? A lot of people in Hollywood, screenwriters, when they come up to me, oh yeah, I have a registration on my copyright. Really, where is it? Well, with the Writers Guild. Well, the Writers Guild does have a registration system, but it's a fraud. It's a sham. All it does is take writers' money, and it has a minimal function, which is it provides a repository that kind of gives a third-party proof that you created a work by a certain point, but it has no legal force. You get the exact same benefit from registering the work with the Copyright Office, plus you get eligibility for the two biggest remedies in copyright law. Number one, recovery of attorney's fees. Number two, recovery of statutory damages. If you can't recover attorney's fees or statutory damages,
you typically don't have much of a case in copyright law, because if you lose the case, you could have attorney's fees assessed against you. But if you don't have a timely registration, you can never get your attorney's fees, no matter how meritorious your case, no matter how willful the infringement. And by the way, if you don't register timely, the willfulness of the defendant's activity is completely irrelevant to the issue of damages and liability also, which is remarkable. So attorney's fees and then statutory damages, which of course can add up quickly. For willful acts of infringement, that's up to $150,000 per act of infringement, or for non-willful, that's up to $30,000 per act of infringement. So you must register the work before the infringement begins. What that means is advising clients, advising technology companies. If you have a piece of valuable intellectual property in the form of a copyright, register it with the Copyright Office and register it properly. Because if a copyright is invalidated, you lose your timely registration date, which means you also lose the ability to get statutory damages and attorney's fees. So in terms of enforcement, registration is absolutely critical. Now, what rights are covered by copyright? Section 106 of the Copyright Act dictates the rights. It's interesting to look at that. I'm sure many of you have over the years, but to not just consider what rights are covered, but what rights aren't covered. The rights that are covered, of course, are the right of public distribution, the right to reproduce a work, the right to create derivatives, the right of public performance for everything except sound recordings, right? And the right of public display. Those are the rights that are covered. What's interesting is if you consider what rights aren't covered. There is no broad transmission right, although that's been debated over the years whether that should be amended to the Copyright Act, and this is an issue that came up in most recently the Aereo case before the Supreme Court. There is no right of private performance, which means you don't violate any copyright exclusive right if you privately perform a work without authorization. And so there are certain limitations to those rights. And of course, the other limitations in the rights of a copyright holder are found throughout the Copyright Act by way of, most notably, the fair use doctrine, the first sale doctrine, the compulsory mechanical license in section 115, which Jay talked about earlier, etc. And then, of course, there is the enforcement of a copyright. As I mentioned, you need a registration. Even if you have not timely registered, you still technically should register your work before you file an infringement claim. And here I just kind of want to mention that there's not just the possibility of direct liability in copyright law, but increasingly, especially, and this is important for technology companies, the possibility of intermediate or secondary liability. So what do I mean by that? Well, first, direct infringement requires a valid copyright. You need to show the defendant had access and that there was substantial similarity between your work and theirs. But there is also the possibility of recovering in certain instances for secondary liability. There are two principal theories of secondary liability. Neither is explicitly mentioned in the Copyright Act. They have been imported in there through the construction of courts by analogy both to the Patent Act as well as to common law principles of respondeat superior. The first theory of secondary liability is something called contributory liability, which basically holds that someone can be found liable for copyright infringement, even if they didn't directly infringe it, if they, number one, knew of someone else's infringement, had knowledge, and two, materially contributed to it, okay? This is basically the mechanism which got liability found against all the peer-to-peer file sharing websites over the last 10 years, or services. They weren't directly engaging in infringement. Why? Because users were. They weren't. They were merely providing a system that would facilitate infringement. And by and large, the courts found that Napster, Grokster, and other entities like that were basically knowingly contributing materially to the infringement of underlying users. There's a second theory of secondary liability, which is vicarious liability. This is akin to employer-employee liability we find in tort law. And basically, it requires two elements. It requires, number one, that you have the right and ability to control the actions of the third party. And number two, that you financially benefit from them. And again, this theory has been used powerfully in cases like the Napster case, the Grokster case, going after technologies. Let me turn my attention now to something called the Digital Millennium Copyright Act, which probably many of you have heard of. and in particular, the safe harbor provisions of the DMCA, which are incredibly important to emerging and new technologies. These are codified in Section 512 of the Copyright Act, and they basically provide a safe harbor from copyright infringement damages liability to certain types of internet service providers under certain conditions. These provisions are basically what enables YouTube to exist. They enable Facebook to exist. They enable Instagram, Tumblr, Pinterest. All of these entities rest on the DMCA safe harbor. The DMCA safe harbor basically says that as an internet service provider, you will not face monetary liability, which, by the way, that means you can face injunctions, but just not monetary liability, under 4 categories. If you're a transitory digital network, if you engage in system caching, if you are dealing with information residing on systems or networks at the direction of users, or if you are providing information location tools. In normal English, the most important one of these 4 in practice is C, information residing on systems or networks at the direction of users. The colloquial term for this is user-generated content, UGC. If you have a website that effectively traffics, allows the uploading, involved in any way with user-generated content, the statute that helps establish your immunization from liability for user-generated content, whether you're a blog, you're a video upload service, you're a pinning service like Pinterest, is Section 512, this provision C, which deals with user-generated content. Now, I mentioned earlier that there are certain prerequisites that you have to perform in order to keep the safe harbor. And the cases have begun percolating through the federal court system where certain internet service providers have been found to comply with the DMCA and therefore, enjoy the safe harbor, and other ones have found not to comply. And this is the difference between existing and non-existing. Because as the famous Viacom versus YouTube case, Viacom sued YouTube for billions and billions of dollars. And of course, if YouTube had lost, it would have faced a judgment that would have been bankrupting. But of course, Google made sure it didn't lose, in part for reasons that Jay alluded to earlier. Suspiciously, Google never seems to lose court cases.
I have a judgment against it.
Congratulations.
I know.
That's very, you may be the only one. I know, congrats.
I can.
That's
real estate.
They don't lose IP cases.
Street View.
Well, that's right. Street View, they did get in some trouble for that. But Google, in the end, was found to comply with the terms of the DMCA safe harbor. Other entities have not been so lucky. And the case law is mixed, but there are 7 major things that you need to do as a technology company that is dealing with user-generated content. The first one, and this is often overlooked, and again, this is one of those procedural niceties that people don't usually think about, but it is literally black and white. You must designate an agent for receipt of takedown notices with the Copyright Office. If you do not designate an agent with the Copyright Office, you per se cannot ever qualify for the 512 safe harbor. A lot of entities forget this. A lot of entities that don't have counsel representing them in the early years don't even think of this. It's not really that well known. But the case law is very clear. If you don't have a designated agent, you haven't gone through the formality of creating a designated agent, you do not get the benefits of the DMCA safe harbor. Second, you need to qualify as an internet service provider under one of the 4 categories that I just mentioned earlier. Third, you can never possess actual knowledge of infringement. Okay? Now, that might lead you to think, okay, internet service providers then should bury their hand in the sand and try to go, I didn't hear that, I didn't see that, I didn't see that. And many of them do. But there's a capturing clause there, which is the 4th factor. You cannot have what is called red flag knowledge or willful blindness. So courts will get you if you are deemed to be burying your head too deep in the sand, such that you are willfully blind to what to everybody else is seen as transparent infringing activity on your network. 5th, you have to promptly reply to any proper DMCA takedown notice That is a notice provided by a legitimate copyright holder that claims that there's infringement on your network. You must promptly reply to it. What does prompt mean? No one knows. The industry standard is 48 to 72 hours, but this hasn't been litigated. Okay? 6, you must have a policy, and you must reasonably implement that policy to terminate the accounts of repeat infringers. What does this mean? No one knows. The case law hasn't been real clear on this. What's the industry standard? 3 strikes. Typically, most websites, again, kind of leading the charge of Google, will basically give warnings, 2 warnings to users. If they receive a 3rd takedown notice, then you must terminate their account. Now, there are many ways that internet service providers play with this, though. They'll say they have a 3-strike system, but really that means they have to receive notices maybe from 3 different copyright holders, not the same one. Or they have to be notices on different days, not on the same day. Or they have to be notices on different weeks, not the same week. So there's a lot of flexibility in this standard. And there really isn't a bright line rule on this. But if they fail to reasonably implement this policy of terminating accounts, they face loss of their DMCA safe harbor. And then finally, you cannot receive a financial benefit and have the right and ability to control the infringements. Okay? So those are the major factors that any company that is starting, that is involved in user-generated content, needs to take into account on a pretty serious basis if you're going to be trying to play in this field, because the DMCA safe harbor is what shields you from potentially billions and billions of dollars of liability. And if people have timely registered their copyrights and you are having user-generated content regularly on your website, you are potentially racking up millions and millions of dollars of liability every day, just as the YouTube case seems to suggest. There's one other notable provision in the DMCA that is worth noting, and Jay alluded to it earlier, which is it's called Section 512F. It's a cause of action that is meant to protect people from overbearing or overreaching takedown notices. It's a mechanism meant to protect user rights instead of the rights of copyright holders. And the famous case involved in interpreting 512F is the Universal v. Lentz case, the dancing baby case, which of course has issued a number of rulings, including the idea that internet service providers need to take into account fair use before they decide to comply with a takedown notice or not. 512F, though, that part of 512F has been unfavorable to copyright holders. But other parts of 512F have been highly favorable to copyright holders. The courts, under the case Rossi as well as in Universal v. Lentz, have held that a copyright holder merely needs to have a subjective belief that what is occurring is infringement. It doesn't have to be objective. So if a copyright holder truly believes that every use of their work is infringing, they truly believe that, that's a subjective belief, even if the case law says otherwise. And so that makes a 512F claim rather difficult in practice to prosecute. And there have been very, very few successfully prosecuted 512F claims. You can see Universal Lentz is now in its 7th year of litigation. And that seemed to be a case where at least the EFF thought they had a pretty good claim on the plaintiff's side, where a mom put up a video of her kid dancing a Let's Go Crazy and thought that was a quintessential case of fair use.
Because I think we're kind of getting short here on
Okay,
time.
well then I will wrap up with that and turn it over to Jay.
Two quick points just as a practice point. As John mentioned on the DMCA, if you go on LOC.gov, Library of Congress, there is a form to file to claim the safe harbor of the DMCA. So almost all of my clients, if they're in the business of acquiring content and that maybe they have to monitor, and I don't know whether they should or they shouldn't, because John mentioned the subjectiveness of it, there is a form. It used to be $80, now it might be $109, I think, to file the DCA form, and you designate your agent. You can also go on the website and search for the DMCA agents for other companies. If you're a would-be plaintiff, you can see who their agent is. Second thing is copyrights and trademarks. There is a border control filing you can make to have your trademark or copyright acknowledged at border control, and that's in the materials if you need a cite.
Jay?
Okay, a couple of things just to follow on the DMCA, and then I'm going to get into copyright registrations just for a second and the problems that might arise. The repeat infringer, there is a recent case, which is still an appeal, which is the Cox Communication case, which might get or might not get overturned, but that does deal with whether or not Cox Communications had a policy in place for repeat offenders. The weirdest part about all of that is that when that case was filed, it was BMG and Round Hill actually withdrew because of problems with their copyright registrations, that they couldn't prove up ownership on everything, but BMG stayed in. The strangest, and this happens in Washington sometimes, NMPA was very much, the organization I was working for, the National Music Publishers, was very much involved in this case, and they were not only on the same floor, but they were literally right outside of our door. So in this major lawsuit, we were suing against them. Cox is there. They have since moved. I don't know whether they moved because of us. We were too loud. I don't know. We were messy. I don't know. But this case does stand for the first time that repeat offender litigation has started based on whether or not they have a policy. That's the interesting part. What that policy is or not, really, they didn't flesh that out too much. They just found that they did. Many other services do have a policy. And if they do, they're protected on that particular issue. The issue of actual knowledge connects directly with what I was talking about with the notice and takedown versus notice and stay down. Right now, the law does say you have to give actual knowledge of the infringement to the service, meaning that every place where it pops up again, you have to give them notification. The notice of stay down provision is supposed to be about taking that out. That's the big issue that relates to that. Now, the issue of ownership and things like mergers and litigation and all of that, to be honest, big publishers don't know what they own in full because of termination rights. Things happen that on some old songs, and there are some termination rights, particularly renewal rights of old songs that occur automatically, and you don't keep that in your systems, in publishers. So publishers can say, I know 99% of what I own, but I'm not sure that the big ones can ever say they own 100%. And this, to a certain extent, plays out with every publisher. So one of the key issues certainly in transactions is what warranties are you giving? And what indemnification must be part of those warranties? You've really got to pay attention to the point of your client may be missing something down the road, and you have to make sure your warranties are loose enough that it can cover most but not all of their catalog at the end of the day. Registrations, copyright registration. I was a copyright examiner first year out of law school. That was my first job. They needed lawyers that could read music. So I was there registering copyrights every day, understanding the cultural output of our country, most of which was really bad. Let me tell you, songs, you have no idea what people register. But some is good. But the point here is that people make mistakes on registrations. It's not all clear. And when you have to do a litigation that occurs well down the road of when the first registrations were filed, and you've got to go back and show chain of title, you might run into problems, not because things weren't registered, but they were registered incorrectly. The lesson is don't underestimate in any way the importance of your registration. At the end of the day, this played out in the Happy Birthday to You case. That there were some registrations that were inaccurate, couldn't show title accurately, and they had to eventually kind of give in at the end of the day. One of the big cases out there in the sound recording side, you've mentioned that sound recordings are not subject to work for hire, was the mp3.com case. And I was involved in this case when I was the general counsel for the Recording Artists Coalition. In that case, which is probably 15 or 20 years ago or whenever, but the labels came forward and filed a major infringement case, one of the first ones under secondary liability against mp3.com. And they filed 4,000, they submitted 4,000 registrations. The reason they wanted the damages to be so high, like $1 billion, that would put the company out of business. And the recording artists at that point were very much involved in the work made for hire controversy. This was very much an issue in Washington for a while because the RIAA, one day in the middle of the night, allegedly, changed the copyright law without telling anybody through a congressman who they knew. They attached it to a trademark bill, actually, and it was a little omnibus bill, and at the end it said, oh yeah, all sound recordings are now works for hire. And this happened, and then everybody found out, and everything went crazy, and there's great stories about, on the Hill, how we repealed. But for a year, it was technically all sound recordings for that year, between passage and repeal, all sound recordings were under this. So this was a big issue with us. So what happened with mp3.com? We find the labels have filed 4,000 registrations, every single one of them identifying the work as a work for hire, the sound recording work. So I go to Judge Rakoff, who maybe some people have been in front of, ex parte, which is really bad, but we did. We called him up and said, this isn't really great. We love the fact that the infringer is going to get hit. We love the damages side, but we don't want these 4,000 registrations used to go forward and to be used, which when you use them in court, it becomes a matter of fact and law. And we're not asking for something really big. We just want the labels to re-register every 4,000 registrations. The judge heard us. We get on a conference call with all the labels, and the judge says, I think I want to know really on each registration, you might have to show me that you actually own this as a work for hire. Getting into the issue of, do they work for you? Is it under the instance and expense test, which is a commissioning party test? A week later, the case settled. Yeah, he went beyond the call of duty in that particular point. My point here is registrations matter. And issues of sound recordings, how folks registered those sound recordings will matter in litigation and when you want to sell your company. And when you enter into a big deal with a service, you got to know what you own and you don't own. So that's just an example in my mind of why that's so important. Never ignore your registrations. And by the way, the fact that it is required for damages and for legal fees makes a lot of international lawyers claim that our law violates both. Because we're not supposed to have a registration requirement in the United States, yet what we have done is really require registration. So this is a contest and a conflict that continues to this day. But all of this has to do with knowing what the hell you own and what you can pass on. So I just wanted to tell basically the mp3.com story, which is a great one on registration. So there you go.
How do you like that for a fast track of this topic?
Seriously.
Yeah. We just raced through that much topic in an hour. Yes, sir.
Are there any particular registration considerations that we should be aware of where the creator of the work is a minor? And somewhat tongue-in-cheek, is there any potential for this gorilla case to have an impact on very, very young minors?
It's an interesting question because
Did you
the law,
compare
right?
children to monkeys?
From a news story I read, I thought that one of the theories why the gorilla couldn't have a copyright is because he didn't understand that he was creating a work.
Well, it's lack of legal agency and lack of consent and all that stuff is attributed to minors, right? In the same way that it would be to an animal. So yeah.
No, there is an issue. There is an issue here, and that comes in a registration where you have to identify how the owning party acquired the work. On registrations, and every single registration is indelibly planted on the back of my brain because I did 75 a day for a year. The key question is you identify the author, then you identify the owner, and you have to put a statement as to how did the owner, if they're not the same, how did the owner get the right? If you say by contract, and that person is a minor, and that minor doesn't have the capacity to contract, and they revoke the assignment in some way, or had revoked the assignment, you might have a registration with inaccurate information, and that registration can be subject to revocation. So it does matter. You really got to dig to get to that point, but it does matter.
But in that situation, wouldn't it be the minor that has the choice of whether to revoke
Yes,
the contract?
totally,
Yes.
totally.
Yes.
It's not the party, it's the minor
I
that
still
can
can't
say.
figure out how the photographer who handed the camera off to the monkey is claiming copyright ownership of the work. That's the, I get the whole argument on the monkey part of it.
Well, it's work for
But I-
hire. I mean,
But-
you hire the monkey, you give them peanuts.
I do not think you meet the CCNC precedent we need.
It's an express. I think they should have authorship if they have hands. If it's pins, no, but hands, that constitutes authorship.
Yes, sir.
Regarding registrations, how would you guys recommend advising a client such as a photographer or a songwriter who, isn't signed, they don't have millions of dollars, but they're in the business of capturing wildlife or in writing music, they have no idea what's going to hit. They can't afford to register every work. Do you tell them every quarter make a book of works? And
Collective works.
And if so,
Yeah.
is there a problem from a statutory damages perspective of having 100 works versus having one work filed 100 times?
There's case law that's split. You could
Yeah,
make an
yeah,
argument that if you only register, let's say you have 100 photos in one registration, there is case law that suggests that'll only give you one statutory damages award versus 100 if you do 100 separate registrations. That said, 100 separate registrations at $35 a pop is $3,500. My advice generally to artists, though, especially if they don't have money, is look, at least register something so you have a colorable argument. We'll deal with the arguments later. And so if they don't have a ton of resources, register under the collective, works provisions, especially photographers. It's actually pretty easy, so long as there aren't work made for hire issues and things like that, to register a whole group of their works at any given time together. And there are also registration services out there now that regularly will work with photographers and register their works.
Yeah, there's also another rule with collective works where you have the ability to, while you say collective work of somebody, you can better identify the collective works on the registration or an attached piece of paper that says that I'm registering 100 photos, here's a description of them. 1, 2, 3, 4, 5, I took this that date, I took that date, whatever it is, that at least will help. If that's
The test for the awards is oftentimes called the independent economic value test. So you have to show that each work has independent economic value to get a separate statutory damages award. So if it's a paparazzi shot of Britney Spears walking on the street and it's 10 shots right in a row, you've got less of a claim as opposed to if it's 10 separate standalone songs that were on one album, for example.
All right, let's wrap this up. We got one question. Is that Dixie?
Okay, regarding trademarks, which can be registered in the state and registered in,
Federally.
federally, it can be very expensive to file a trademark federally. So what is the difference in remedy between filing a trademark in the state and filing it federally?
I don't ever recommend that my client file a state trademark registration. I think it's completely worthless. If you're a restaurant located on Main Street in a city and you're never going to branch out past that Main Street in that city, the need for a federal registration or even a state registration is very small. But if you are planning to sell your product or your services outside of that area and geographically broadly, you want a federal trademark registration. The filing fees, look, the legal fees are much more than the filing fees, obviously. But if you're filing these things on your own, it's $250 now or $275? $275
Or $325.
Or $325 if you can't sit within the manual of acceptable definition, whatever they call it. If you can't do it specifically within the manual, you can do it for $325. That's per class. So if you have a product that's being sold in 10 different classes, obviously that's going to cost a lot more because you're going to have to cover those classes. But of course, if you're selling a product that sells in 10 different classes, I really hope that you're making some money on it. But it's very important to have that federal registration over a state registration. State registration is a money-raising, revenue-raising device for the state.
It basically codifies the common law, so it's like you're not getting anything extra, it's just you're going into an index that almost mirrors what you would have had a common law anyway. I don't tell clients not to necessarily do it, but
I don't recommend them to do it either.
Yeah, right, exactly.
Could that restaurant, that example, even get a federal registration though?
You can get a federal registration.
They tend to use, right, but in their time, whether or not, or?
If you're using a mark on a restaurant that you're operating in, say, Buffalo, New York, right, and you go say, I want a federal registration, and you register the mark, Under the Dawn Donuts case, you don't get the rights federally until you start using that mark in the other states, in the other area, in other geographic areas. So if somebody in California started using your restaurant name, you have no right to go in and tell them to stop until you expand to California. So it doesn't really make sense for someone who has absolutely no intention of ever going out past to spend the money to register, or let alone try to go and stop people from using their marks. Most of my clients who have come in for those limited purposes don't want to spend the money to register a trademark federally that they're not going to use past their very local little
Yeah, but if you
area.
got the federal trademark, generally the company from California is gonna look at that and say, maybe we should call it something else, just so they don't move out there and all of a sudden open one up. And
That's
all of a sudden
true, but
they're
that-
changing their brand midstream.
It's true, but if you don't have an intention, why would you even hire,
Well, you can't even file without the intention, right?
Right, you have to have-
Okay, but your point's well taken, but what you can do in that case is, let's say you have a mom and pop, or you have a new client, arguably no federal commerce at this point, so no jurisdiction because you haven't crossed the state line. What you could do is, if it's a restaurant, for example, so it's a service, services can hit interstate commerce with advertising. So you get a local restaurant website, say, come to New Orleans, right? And come from your state and you can get a gift certificate to come into New Orleans. And so you're advertising to come in, you can do it, okay? And then you can, so that's how you get the mark and keep somebody from California from taking
So
it.
would advertising across to the whole country give you copyright rights?
It's gotta be bona fide.
Yeah,
It's gotta be bona fide, but I'm just giving you I'm giving you a tool. How you use it is
But also, I think it's a preventative measure, that you're preventing other people from doing it, because who knows what your restaurant's gonna do? It might do great, and all of a sudden you're franchising it out, the next thing you wanna go to California. If you're not gonna file that, you don't have a choice of not going to California, because the California person already opened up under that, and so you've lost that.
This happens
that
from
whole
time to
area.
time, though. I have clients that come in after they've been using the mark for several, I just had this the other day, a client that's been using the mark for 20 years and has absolutely no intention of going out past where they are.
Right, or you've got the restaurant, the California person opens up, and you chose not to do the federal, and all of a sudden the California person says, well, I'm gonna do a federal, and I'm gonna
Absolutely.
franchise it out.
Well, that's the
And all of a sudden-
McDonald's.
Right.
We had that with McDonald's in New York and New Jersey, by where I live. There was a McDonald's steakhouse for 1 billion years. And McDonald's, opened their stores all over the place, and they got crazed from it, and they were, what do you mean? You can't, we're McDonald's here. And they're, they hadn't federally registered. They were a small, one shop, they were allowed to continue to operate. McDonald's, the hamburger chain, it was a concurrent use application. That small little geographic area was accepted out. They were allowed to continue to use the mark within that small geographic area, and then eventually they went out of business, and that was the end of that.
Yeah, and Dixie made a kind of interesting point. She's talking about the expense of it. I get clients all the time when they come in, they've got the new company, and they're going through my legal bid on basically what all they need done. They're like going through, well, we need to get all this. Maybe we'll just put off trademark until later, because it's a little more expensive. I'm like going, you're out of your mind. Do that first. Get your brand protected. You get it protected at early stage.
That's really good advice. I mean, that's the first thing I tell them all the time. I always, one of the things I used to tell my client when I taught this class to lay people, and they ask, when do I register my trademark? And my answer usually was if it'll cost you $5,000 or more to change your mark in goodwill, in your sign, in your paperwork, in whatever it is, that's probably about the time you should start looking into registration. If it's not going to cost you anything, if it doesn't matter, I have film clients who have film production companies, don't really care. It's like in the beginnings. And if they have to change it, they'll change it. And that's up to them. That's a business decision that they'll have to make. But it's so crucial to have that right, because it is, we all know, we've been talking right here, your intellectual property is the value of your business.
And you might be an infringer.
And you
If you don't check, you might be an infringer.
Right?
Yeah, right. If you don't know, you don't know, right?
It's a topic that we could have gone on for this
Hours.
entirely. They could have dedicated a day to this topic, and we brought in a patent person to cover all of this. But all of us are probably starting to have a lot more technology companies and getting involved with that these days, especially because the entertainment industry is in the technology industry now. That it's synonymous with them. So it's protect the assets. And, you know, I teach the kids in the college and the entrepreneurship class. I go, it's all about assets. It's all about due diligence. It's all about prepping it for the sell and the exit strategies. And so trying to determine where's your money, protect it, and put it in your pocket later. So, thank you all for having us. And again, thank you for having us.